Hello everyone. So today we are going to, as you can see yourself behind me, we are going to do a discussion on the scanners of CA Foundation Partnership Act. The scanners, obviously you will get a different variety of questions and almost it covers up all the topics that are there in the act. So it kind of acts as also a revision for the entire act. So these scanners contain questions from the RTPs from the previous year question papers and the mock test papers that the institute conducts every term. If you want to find these documents, the link for the Telegram channel has been given below. You can click on that, join the channel. You will be updated with all the documents and videos that we share. So, starting with the first one, what is the difference between partnership and HUF? So, many a times, many of you ask me that how many points am I supposed to write? So, let's say if the question is for 5 marks, you can write 6 to 7 points, right? Similarly, if the question is for 2 or 3 marks, you can write at least 4 to 5 points. What's the difference between partnership and HUF? Partnership is created by an agreement, whereas HUF is created by what? It is created by status. That means you're born into the family, you're a part of the HUF. A minor cannot be a partner of a partnership firm, but a minor can be a part of the HUF. That is, he's a member of an HUF. In partnership, every partner has unlimited liability, whereas in HUF, only the Karta has unlimited liability. Death of a partner results in the dissolution of the firm. Death of the Karta does not result in the dissolution of the HUF. The next eldest member becomes the Karta of the family. Then every partner has a right to check the books of accounts, but in case of HUF, the Karta has a right to check the books of accounts. Partnership is governed by Partnership Act, HUF is governed by Hindu law. Difference between partnership and joint stock company. So, a partnership when we talk about partnership, partnership does not have a separate legal entity, whereas a company has a separate legal entity. In fact, all the characteristics of company is derived from this concept of separate legal entity. Partnership is not mandatory that the partnership firm has to be registered. So even orally a partnership firm can be formed, but in case of company, it has to be registered. The liability of a partner is unlimited, whereas the liability of the member is limited to the unpaid value of the shares held by them. Then death of a partner results in the dissolution of the firm. Death of a member does not result in the dissolution of the firm. Property of the partnership belongs to the partners, whereas property of the company belongs to the company. Business of the partnership is generally managed by the partners, all of them together or any one or more acting for all of them. Whereas in case of company, the business is managed by a separate body called the board of directors. Shares is not easily transferable in partnership. I need the consent of all the partners. But in case of company, the shares of a company are freely transferable. In case of private company, we can put restrictions, but we cannot say that the shares are not transferable. Whereas in case of public company, it's freely transferable. Partnership minimum partners is 2, maximum is 50 as per the rules. Whereas in case of company, in case of a private company, minimum is 2, maximum is 200. In case of public company, minimum is 7, maximum is unlimited. In case of OPC, it's only 1. What is the difference between partnership and co-ownership? So partnership is formed only by agreement. Co-ownership can be formed either by agreement or by operation of law. Partnership, partners are the agents of each other, but in co-ownership, the co-owners are not the agents of each other. In partnership, the motive is business, whereas in co-ownership, the motive of business may or may not be there. In case of partnership, the share of a partner can be transferred only with the consent of all the other partners. Whereas in case of co-ownership, I don't need the consent of the others to sell my shares, right? We can say that all partners are co-owners of the property of the partnership firm, but all co-owners are not partners. Define partnership and name the essential elements for the existence of partnership. Explain any two such elements in detail. Partnership as defined under section 4. Partnership means a partnership is an agreement between two or more persons to share the profits of the business carried by all or any one or more acting for all. And from this definition itself, we get the characteristics of partnership. First of all, partnership, there has to be an agreement. The agreement is for sharing of profits. The profits are derived from business and the business is carried by all of them together or any one or more acting for all. When we talk about partnership, when we talk about agreement, partnership can never arise out of status. There has to be an agreement. The agreement can be oral, it can be written, it can be expressed, it can be implied. Right? When it is written, the deed where we mention the clauses is known as partnership deed. Minimum is 2, maximum is 50. If the number is more than 50, it becomes an illegal association. In case of, what do you say? The next essential, sharing of profits. Why do we only say sharing of profits? Because we can have partners who do not share the losses. So sharing of profits does not necessarily mean sharing of losses. But obviously when the partners share profits, they will also bear the losses, but it's not implied. We can have partners who do not share the losses. Now in case of sharing of profits are shared as per the agreed ratio, and if nothing is agreed equally, losses are shared as per the agreed ratio, and if nothing is agreed, they are shared as per the profit sharing ratio. Now where do I get the profits from? Business. So what is business? Any trade, profession or occupation which is recurring in nature. And who will carry this business? Any one of them, all of them, or any one or more of them acting for all. So when we say acting for all, that means what? He is making the contract, he is acting on behalf of all of his partners. That means all of his partners are liable for the act that he has done or for the acts that he does in the name of the firm. Partner indeed virtually embraces the character of both principal and agent. Describe the statement keeping in view the provision. So basically what happens is, let's say there are 3 partners and A carries the business on behalf of the firm. So A acquires a twofold character. He is both agent as well as principal. So let's say the firm wants to contract with T. Now since A is contracting in the name of the firm, who will go and make the contract? A will make the contract. So when A goes to contract with T, he is the principal. For T, he is the firm, so he is the principal. But when he goes and contracts with T on behalf of his other partners, for his other partners, he is the agent. So this active partner, whoever is doing the business in the name of the firm, he is not just the agent or the principal, he is both agent as well as principal for the purpose of the business of the firm. Sharing in the profits is not the conclusive evidence in the creation of partnership. When partnership agreement is written, we know there is a partnership agreement. But when the agreement is implied or when the agreement is oral, we need to test the partnership. So when I see 2 or more people, they are sharing profits, I can say they are partners. But that's not conclusive, that's just the first look. I can look at the relation, and if I see they are sharing profits, I can say they are partners, but it's not conclusive. But if on further investigation, I see mutual agency, then I can say they are partners. So sharing of profits is not the conclusive evidence. Sharing of profits is the prima facie evidence. That is the first evidence. That is when I look at the relation of 2 or more people and I see they are sharing profits. First look, I can say, okay, they can be partners, but I need to make a further check. And when on further check, I see that there is mutual agency, then I can conclude that there is a partnership. What is the conclusive evidence? We already discussed this question. Mr. Ram and Mr. Rahim are working as a teacher in Ishwar Chandra Vidyasagar Higher Secondary School and are also very good friends. They jointly purchased a flat which was given on rent to Mr. John. Giving a property on rent is not a business because it's not considered as recurring in nature. It is not done with a motive of profit, right? So this is not business. So if it is not business, Mr. Ram and Mr. Rahim cannot be considered as partners. It was decided between the landlords and the tenant that the rent would be 10,000 per month inclusive of electricity bill. It means that electricity bills will be paid by Mr. Ram and Mr. Rahim. The landlord by mistake did not pay the electricity bill for the month of March 21. Due to this, the electricity department cut the connection. Mr. Jones has to pay the electricity bill of 2,800 and 200 as penalty to resume the electricity connection. Mr. Jones claimed 3,000 from Ram, but Mr. Ram replied that he is liable only for 1,500. Mr. Jones said that Mr. Ram and Mr. Rahim are partners, therefore he can claim the full amount from any one of the partner. Explain whether under the provisions of the Indian Partnership Act, Mr. Ram is liable to pay the whole amount of 3,000 to Mr. Jones. Here, if they were partners, in case of partners, the liability is what? Severe. If they were partners, anyone could have been held liable for the whole money. But since they are just co-owners, they are not partners, they are joint owners, they are only liable for their respective share. So Mr. Ram is not liable to pay 3,000, he is only liable to pay 1,500, and Mr. Jones can recover the other 1,500 from Mr. Rahim. Business carried by all or any one of them acting for all. Discuss the statement. I've already explained this to you about the the principal and agent concept. So we already know about this. A and B jointly own a car which they use personally on Sundays and holidays and let it on hire as a taxi on other days and equally divide the earnings. Just because they use it on Sundays personally doesn't mean it cannot be business. They are giving it on hire on other days. So yes, it is partnership. Two firms each having 12 partners combined by an agreement into one firm. No problem, two firms can form partnership. But always remember, it is not the firms which are becoming partners, it is the partners of the firm which are becoming partners. So basically there will be 2 partners or 24 partners. There will be 24 partners. A and B co-owners agree to conduct the business in common for profit. Now just because they've used the word co-owners doesn't mean it cannot be partnership. I already told you partners are co-owners of their property. They are conducting business. It's given they are conducting business for common profit. So that's what partnership is. So are they partners? Yes. Some individuals form an association to which each individual contributes 500 annually. The objective of the association is to produce clothes and distribute the clothes free to the war widows. This is an association which is not for profit. One of the main motive of partnership is profit. And unless there is profit, it cannot be partnership. So yes, definitely this is not partnership. A and B co-owners share between themselves the rent derived from a piece of land. Giving a property on rent is not considered as business. No. A and B buy commodity X and agree to sell the commodity with sharing the profits equally. Is this partnership? Yes, because this is what? Particular partnership. But when you give a property on rent, please remember, rent is not considered as what? Rent is not considered as business. What do you mean by partnership for a fixed period? A partnership which is formed for a specified period of time. Once the period is over, the firm is dissolved. But if the partners want, they may continue. And if they continue, it becomes a partnership at will. What is particular partnership? What is partnership at will? Particular partnership which is formed for a specific purpose. Once the purpose is over, the firm is dissolved. However, if the partners want, they may continue, and if they continue, it becomes a partnership at will. What is partnership at will? Will, Mary, mercy. No time is given to determine the partnership. That means what? We will continue the partnership as long as we want. Right? We will continue the partnership as long as we want. One of the main features of this partnership is that any partner can give a written notice and retire from the firm or dissolve the firm. X and Y are partners in a partnership firm. X introduced A manager as his partner to Z. A remains silent. So this is what? Partners by estoppel or holding out. Z, a trader, believing A as partner, supplied 100 TV sets to the firm on credit. After the expiry of credit period, Z did not get the amount of the TV sets sold to the firm. Z filed a suit against X and A for the recovery of the price. Advise Z whether he can recover the amount from X and A. X is a partner of the firm, so he is anyway liable. The question is whether A is liable. When a partner of the firm represents another person as a partner to a third party and such person does not deny it. Was A the partner? No. But he was represented as a partner by a partner of the firm and A kept quiet. He becomes a partner by estoppel or holding out, and his liability shall be what? He will be liable for the contract because the contract was made believing A was a partner. A is liable and his liability shall be what? Shall be severe. Right? His liability shall be severe. What is a nominal partner? A partner who lends his name to the firm. Why would he lend his name? Because of the goodwill associated. He generally brings in the goodwill. So generally he does not bring in capital. But that doesn't mean he cannot bring in capital. That's totally the contract of the partners, because partnership is something which is based on contract or agreement between them. And because it's based on an agreement and law does not as such say anything, they have a right to choose and decide on it. Generally, he lends his name to the firm because of the goodwill, so he does not give his name to the firm. He does not even take, he does not bring in capital to the firm. He does not even, do the business of the firm. Generally, he does not even take profits and losses because he gets a fixed royalty. But he is known to the outsiders, he is liable to the outsiders, and when he retires, he has to give a notice of his retirement. Otherwise, he will be liable. Mohan, Sohan and Rohan are partners in a firm, Messrs. Mosoro and Company. They admitted Mohan as nominal partner, and on agreement between all the partners, Mohan is not entitled to share profits of the firm in the firm. So basically, he gets what? He gets a fixed royalty. After some time, a creditor, Karan, filed a suit to Mohan. First of all, is a nominal partner liable? Yes, a nominal partner is liable because I'm going to the firm because of his name. Bohan denied the same, as he is just a nominal partner and he is not liable. His denying is not correct because he is liable. And Karan should claim his dues from the other partners, taking into account whether Bohan is liable. Yes, Bohan is liable. In case Karan had filed the suit against the firm, whether Bohan would be liable? Yes, Bohan would be liable. Whether a minor may be admitted in the business of partnership firm, explain the rights of a minor. A minor cannot be a partner of the firm, however, he can be admitted to the benefits of the firm. When a minor becomes a beneficiary of the firm, the rights of the minor are he will get his share of profits, he can check, inspect, and copy the accounts of the firm, he can sue the other partners for his share. That is, if he does not get his share, he can even sue the other partners for his share, provided he severs all his connections with the firm. When on attaining majority, within 6 months from the day he attains majority or the day he comes to know he was a beneficiary, whichever is later, within 6 months from that day, he must give a notice of whether he wants to become a partner or not. If he fails to give notice, he automatically becomes the partner of the firm. Liability of a minor while he is a minor. As a minor, he will not be personally liable. Liability is only against his share in partnership. When a minor on attaining majority becomes a partner of the firm, rights will be the same as it was, and he is liable from the day he was admitted to the benefits. Yes, bachpan ke din, right? From the day he was admitted to the benefits of the firm. State the legal position. We've already discussed this, so I'm not going into this. Even this, referring to the provisions, what are the liabilities, what are the rights, we've already discussed this. Master X was introduced to the benefits of partnership, Messrs. ABC and Company, with the consent of all the partners. After attaining majority, more than 6 months have lapsed and he failed to give public notice. So when he failed to give public notice, what will happen? He will become the partner of the firm. As to whether he elected to become or not to become a partner in the firm. Later on, Mr. L, a supplier of material to Messrs. ABC and Company, filed a suit against Messrs. ABC and Company for the recovery of the debt due. So when he filed a case, will X also be liable? Yes. And so to what extent will X be liable if he failed to give notice? He will be liable like any other partner. The liability of X will be like any other partner. Can L recover his debt from X? Yes, he is liable like any other partner. So the money can be recovered from X. Right? So moving on to the next one. Moni and Tony were partners in firm Messrs. Moto and Company. They admitted Sony as a partner in the firm and is actively engaged in the day-to-day activities of the firm. There is a tradition in the firm that all the active partners will get a monthly remuneration of 20,000, but no express agreement was there. Remuneration, when we talk about right to remuneration, remuneration is basically not a right of a partner. But remuneration is payable if there is an agreement or if there is a custom of the firm. So in any one of these cases, remuneration is payable. After admission of Sony in the firm, Moni and Tony were continuing getting salary from the firm, but no salary was given to Sony from the firm. Since he's an active partner, he's entitled to get. Sony claimed his remuneration but denied by existing partners by saying that there was no express agreement. Whether under the partnership can he claim? Yes, he can claim remuneration because remuneration is payable either in case of an agreement or if there is a custom. What do you mean by goodwill? Goodwill is considered to be a property of the firm subject to a contract between the partners. A, B and C are partners of a partnership firm carrying on the business. Math will get questions. These kind of questions will only be for 2 marks, right? Because there are only 2-3 line of answers. You cannot create something on your own to write it, right? So these questions, this question would generally be for 2 marks. A, B and C are partners, and even if it is, let's say, no ma'am, it was 2 marks question, they gave it for 4 marks. So you just have to write whatever is there to write. You cannot add up anything. So it's okay. A, B and C are partners of a partnership firm carrying on the business of construction of apartment. B, who himself was a wholesale dealer of iron bars, was entrusted with the work of selection of iron bars after examining its quality. As a wholesaler, B is well aware of the market conditions. Current market price of iron bar for construction is 350 per kilogram. B already had 1000 kgs of iron bars in stock which he had purchased before the price hike for 200 per kg. He supplied iron bars to the firm without the firm realizing the purchase cost. That means, can we say he is earning what? He is earning secret profits from the firm. Correct or not? Is B liable to pay the firm the extra money he made? Is B liable to pay the extra money he made? Yes. If a partner earns any profits from any transaction of the firm or by using the name of the name or assets of the firm, he has to give the share of the profit to the other partners, right? So, or he doesn't have to inform the firm. It is his duty to inform the firm. Assume there is no contract. So, even if there is no contract, it is his statutory duty that he has to inform the other partners. And if he does not inform, makes a secret profit, he has to give a share of the profit to the other partners. Oops. Discuss the provisions regarding personal profits. So here we have 3 things here. If a partner earns any personal profits from any transactions of the firm or by using the name or assets of the firm or by carrying on any business which is competing with that of the firm, right? So either from any transactions of the firm or by using the name or assets of the firm or by a business competing with that of the firm, he has to give a part of the profits to the other partners. Whether a group of person is or is not a firm or whether a person is or is not a partner. What is the proof of existence of partnership? This you have to write again about true test of partnership, which we had already done. Sharing of profits is the prima facie evidence. Oops, there is a, wait. This answer is wrong. There is some error here. Okay, there is some error here. Here we have to write about this, the test of partnership. So this, the cardinal, this thing, this would be the answer actually. Conclusive evidence of partnership. Okay, this will be the answer actually. Chalo. So anyway, moving on to the next one. Define implied authority. In the absence of any usage, the implied authority of a partner does not empower him to do certain acts. State the act. So what is implied authority? Implied authority of a partner means the authority. So this is actually the answer. Guys, this is the answer for this question. Actually, this has been interchanged. Okay. So this answer is for this one and this answer is for this one. Please make sure that you don't make any mistakes. So what is implied authority? Implied authority of a partner means the authority of a partner to act in the name of the firm and to bind the firm by his acts. However, the act must be done in the usual course of the business. If it is not done in the usual course, the other partners are not liable. But that is, the firm is not liable. But if it is not done in the usual course, but the other partners ratify it, the firm is liable. There are, however, certain acts, in fact, there are 7 acts which is not within the implied authority. He cannot submit a dispute relating to the firm to an arbitrator. He cannot open a bank account in his own name. He cannot transfer any immovable property on behalf of the firm. Transfer includes both sale and purchase. He cannot admit any liability against the firm. He cannot compromise or relinquish the debts of any person. He cannot withdraw any suit filed on behalf of the firm, right? And he cannot enter into a partnership on behalf of the firm. That was one point I missed out. A, B and C are partners of a firm. The firm is a dealer in office furniture. A was in charge of purchase and sale, B was in charge of maintenance of accounts, and C was in charge of handling all the legal matters. Recently, through an agreement among them, it was decided that A will be in charge of maintenance of accounts and B will be in charge of purchase and sale. Can the implied authority of a partner be extended, restricted, or changed? Yes, by an express agreement. But this is something which is internal to the partners. So how does it affect a third party? If the third party knows about this change, the third party is bound by this change. But if the third party does not know about this change, the third party is not bound by such change. Here, being ignorant about such agreement, M, a supplier, supplied some furniture to A, who ultimately sold them to a third party. Referring to the provisions of the act, advise whether M can recover the money. Yes, because he was not aware of it. He was what? He was ignorant about the agreement. So since he was ignorant about the agreement, he can go and recover the money from the firm. Because if any change in the implied authority of a partner and if the third party does not know about it, he is not bound by it. What will be your advice in case M was having knowledge about it? Now, if M knew about it, okay, if M knew about it, then he is having knowledge. So, he cannot hold the firm liable. In the absence of any usage or custom of trade, the implied authority of a partner does not empower him. So, the act we have already just discussed it. Shyam, Mohan and Keshav were partners in Messrs. Nand Lal, Gokul Wale and Company. They mutually decided that Shyam will take the responsibility to sell the goods, Mohan will do the purchase and Keshav will look after the accounts. No one will interfere in others' department. Once when Shyam and Keshav were out of town, Mohan got the information that the price of their goods is going down sharply due to some government policy which would result in heavy loss to the firm if the goods are not sold immediately. He tried to contact Shyam, who has authority to sell the goods. When Mohan couldn't contact to Shyam, he sold all the goods at reduced price to save the firm from heavy loss. Thereafter, Shyam and Keshav denied accepting. Generally, a partner has no authority to do the work for which he has not been given an authority. However, in case of an emergency, That means if his implied authority does not empower him, he cannot do the work, and if he does the work, the firm is not liable. But in case of an emergency, if a partner acts with the outside his authority just to save the firm is liable. Here, he was unable to contact Shyam. He was unable to what? He was unable to contact Shyam, and the reason he took the step to sell the goods is to protect the firm from loss. So is the firm liable? Yes. So they denied accepting the loss due to sale of goods at reduced price as it's only Shyam who has the express authority to sell the goods. Discuss the consequences. The firm is liable. Why? As act in, because it's an act in emergency and it is done to protect the interest of the what? Firm. Firm would suffer huge losses. So to protect the interest of the firm, this act was done. So the firm is liable. That means the sale will be binding on the firm. Explain in detail the circumstances which lead to liability of the firm for misapplication by partner as per the provisions. Okay. There are two cases here. If a partner acting in the ordinary course of the business receives money from a third party on behalf of the firm and misuses it, or a third party pays money to the firm and a partner misuses it, in both of the cases, who is liable? The firm is liable. A, B, and C are partners in a firm called ABC firm. A, with the intention of deceiving B, a supplier of office stationery, buys certain stationery on behalf of the firm. The stationery is of use in the ordinary course of the firm's business. A does not give the stationery to the firm, instead brings it to his own use. The supplier D, who is unaware of the private use, claims the price from the firm. Is the firm liable? Is the act done in the ordinary course of the business? Yes. Is the act done in the ordinary course of the business? Yes. Ma'am, how is the act done in the ordinary course of the business? So is the firm liable? Yes. But ma'am, it was A's fault. No, so the firm can recover from A, but as far as the third party is concerned, the firm is liable. The firm refuses to pay for the price on the ground that the stationery was never received by it. Referring to the provisions of the Indian Partnership Act, decide whether the firm's contention is tenable. No, the firm will be liable to pay the money. Right? So they contending that they are not liable because the firm never used the stationery is not valid. It was done in the ordinary course of the business. The firm is liable. What would be your answer if a part of the stationery purchased by A was delivered to the firm by him and the rest of the stationery was used by him for private use, about which neither the firm nor the supplier D was aware? It doesn't make a difference. The answer would still be the same. He uses half the stationery, he uses full stationery, he uses no stationery. Doesn't make a difference. In the end, the firm is liable. What do you mean by implied authority? Point out the extent of partner's implied authority in case of emergency. So, implied authority means the authority of a partner to act in the name of the firm. The act must be done in the usual course of the business. If it is not in the usual course, firm is not liable. Any act done by a partner which is outside his implied authority shall not bind the firm. However, in an emergency, if with an intention to protect the interest of the firm, a partner does any act which is outside his authority and the third party does not know it is outside his authority, the whole firm will be liable. So it's only in the case of emergency, if he does any act, then it will bind the whole firm. Mahesh, Suresh and Dinesh are partners in a trading firm. Mahesh, without any knowledge or consent of Suresh and Dinesh, borrows himself 50,000 from Ramesh, a customer of the firm, in the name of the firm. It's a trading firm. So for a trading firm, taking a loan is actually the usual course of the business. Mahesh then buys some goods for his personal use with that borrowed money. Can Ramesh hold Suresh and Dinesh liable? Yes. Any act which is done in the usual course can bind the whole firm. But ma'am, it was Mahesh, so he will be liable to Suresh and Dinesh. As far as the third party is concerned, the whole firm is liable. What is the provision related to the effect of notice to an active partner? Notice here, as I told you, doesn't mean only a written notice. Notice here means the knowledge of a fact. Notice to an active partner is deemed to be a notice to the firm. right? Notice to an active partner is deemed to be a notice to the firm. However, it should be what? It should be actual and not constructive. That is, it should be a real notice and not a made up notice. Whether a minor may be admitted in the business of a partnership firm. Explain the rights of a minor in the partnership firm. We already discussed this, not going into it. A, B, and C are partners in a firm. As per the terms of the deed, A is entitled to 20% of the partnership profits. A retires from the firm and dies after 15 days. B and C continue business without settling the accounts. What are the rights of legal representatives? First, they will get their share, and if they continue without settling his share, he will get a share of the future profits, or his share will be treated as a loan and he will get interest on advance. Right? Can a partner be expelled? If so, how? What factors should be kept in mind? Yes, a partner can be expelled. How? By consent of majority in express agreement and good faith. Expulsion is considered to be in good faith if it is in the interest of partnership. The partner to be expelled is served with a notice and partner is given an opportunity of being heard. When all of these factors are present, then we can say that the expulsion is valid. If it is not in good faith, expulsion is null and void. Mr. A, a transferor, transfers his share in a partnership firm to B. Mr. B is not entitled to few rights and privileges. Discuss in brief. So, Mr. B, what will be the rights of Mr. B? He will get his share of profits. He cannot take part in the business of the firm. He cannot check, inspect, and copy the accounts of the firm. On dissolution, he will get his share, and to determine his share, he will be given a statement of affairs as on that day. Right? So, moving on to the next one. Ram and Company, a firm, consists of three partners A, B, and C having 1/3 of share each in the firm. According to A and B, the activities of C are not in the interest of partnership and so they want to expel C from the firm. Advise A and B whether they can do so, quoting the relevant provisions. Yes, they can do so. The points that we had discussed above, same points. If that is there, they can expel the partner. Expulsion is one hot favorite topic of the institute. A, B, and C are partners in Messrs. ABC and Company. The firm has decided to purchase a machine from Messrs. LMN and Company. Before A and B purchased the machine, C died. The machine was purchased, but thereafter A and B become insolvent and the firm was unable. Before A and B purchased the machine, C was dead, unable to pay for the machine. Is C's estate liable? No. The estate of the deceased partner, right, is liable for the acts of the firm before his death. Is liable for the acts of the firm before his death. So before his death, whatever act was done, we are liable for that. We are not liable for the acts after his death. So not liable. Messrs. XYZ and Associate, a partnership firm with XYZ as senior partners, were engaged in the business of carpet manufacturing and exporting to foreign countries. On 25th August 2016, they inducted Mr. G, an expert in the field of carpet manufacturing, as their partner. On 10th Jan, Mr. G was blamed for unauthorized activities and thus expelled from partnership. Examine whether the action of partner was justified or not. See, for expulsion, what is most important is good faith. If it is in good faith, it's valid. What is good faith? First, we need partnership interest, right? Second, the partner to be expelled should be given a notice, and third, he should be given an opportunity of being heard. Now, one thing we know that he was doing activities which is against the partnership interest. This is proven, but we don't know about these two. So if I just say justified yes is not correct, no is not correct. But I know that to some extent expulsion is correct because he was doing something which was against the interest of partnership. But I don't know he was given a notice or not. So the best way to write such answers is yes, it is correct provided he was given a notice and an opportunity of being heard. Right? If these 2 points are present, then it is valid. So if you just finish off on this note, it's a better answer. What should have been the factors to be kept in mind prior to expelling a partner from the firm by other partners according to the provisions? So again, the same thing, good faith, no, partnership interest, served with a notice and given an opportunity of being heard. State the modes by which a partner may transfer his interest. A transfer of shares may take place by way of sale, pledge, or mortgage, where a partner may transfer a part or whole of his share to another. Okay. What are the rights of such transferee? We've already discussed this though. He shall have a right to get his share of profits. He cannot take part in the business of the firm. He cannot check, inspect, and copy the accounts of the firm. On dissolution, he will be given his share, and to determine his share, he will be given a statement of affairs as on that day. Mr. M is one of the four partners in Messrs. XY Enterprises. He owes a sum of 6 crores to his friend Mr. Z, which he is unable to pay on due time. So he wants to sell his share in the firm to Z for settling the amount. In the light of the provisions, discuss each of the following. Can he validly transfer his interest? To transfer his interest, he has to get the consent of all the partners, or there should be an agreement which says that he can transfer the shares. Rights of the transferee we have already discussed. I am not going into that. Discuss the liability of a partner for the act of the firm and the liability of the firm. So basically my laptop has its own mind. So discuss the liability of a partner for the act of the firm and the liability of the firm for the act of the partner to third parties. So basically when we talk about for the act of the firm basically means what act done by all the partners or any one or more of the partners or the agents of the partners. For the act of the firm, any act done by a partner while the firm was in existence in the name of the firm binds the firm by his act. That means any act done by the partner during the existence of the firm is liable even after its dissolution, right? Then, so this was contractual liability. Then we had the second liability, which was liability for tort. That is where a partner acting in the ordinary course of the business and with the consent of the other partners, if he commits a tort, the whole firm is what? The whole firm is liable. Then, if a partner has to give cash to the firm, and he gives cash to the firm and a partner misapplies it, or if a partner has to give cash to the firm and he gives it to a partner on behalf of the firm and that partner misapplies it, in both the cases the firm is liable. A, B and C are partners in a firm. So we have already done this, no? Rights of A's. Yeah, this question was already there. It's a repeated question. When can the continuing guarantee be revoked? In case of continuing guarantee, if there is no agreement to the contrary, any change in the constitution of the firm will result in the revocation of the continuing guarantee with respect to future transactions. M, N and P were partners in a firm. The firm ordered JR Limited to supply the furniture. P dies and M and N continue the business in the firm's name. The firm did not give any notice about P's death. In case of death, we don't have to give any notice to the public. The furniture was delivered to the firm after P's death. Fact about the death was known to them at the time of delivery. Afterward, the firm became insolvent and failed to pay the price. Whether P's estate? No. For the act of the firm after the death of a partner, the estate of the deceased partner is not liable. Whether does it make any difference if JR Limited supplied the furniture believing that all the three partners are alive? No, it doesn't make any difference at all, because when we talk about liability of a partner, the partner is only liable up to his death, and when we talk about death, we don't have to give any notice to the third party. So even if no notice was given to the third party is not liable at all, right? The third party is not liable at all. Ram, Mohan and Gopal were partners in a firm. During the course of partnership, the firm ordered Sunrise Limited to supply a machine to the firm. Before the machine was delivered, Ram expired. They just ordered the machine. The machine was never delivered. It was just ordered. The partner who is dead is not liable. The machine, however, was later delivered to the firm. Thereafter, the remaining partners became insolvent. Whether Ram's estate? No. The machine was only ordered. It was never accepted. It was never delivered. The contract was never made. and the partner is the estate of a deceased partner is only liable for the acts before his death, so not liable. Against whom can the creditor obtain a decree? Decree means judgment from the court for the recovery of the price. It can only be against the surviving partners, that is against the partners who are alive, that is Mohan and Gopal. He has no rights over Ram or his property at all. P, Q, R and S are partners in Messrs P, Q, R and RS and Company, a partnership firm which deals in trading in washing machines of various brands. Due to the conflict of views between the partners, P and Q decided to leave the partnership and started competing business on 31st July. When a partner retires, can he carry on a competing business as that of the firm? Yes, if the agreement does not stop him. In the name of Messrs PQ and Company. Meanwhile, R and S have continued using the property in the name of Messrs PQRS and Company, in which P and Q also have a share. Right? Um, Meanwhile, R and but based on the above, what are the rights of P and Q to start a competing business? Can they start? Yes, if no agreement to the contrary. That is, if the agreement does not stop, if the agreement does not stop them, they have a right to carry a competing business. Rights of P and Q regarding their share. They should get their share. And if their share is not given to them and the firm carries its business, then they will get subsequent profits or interest on loan. We have already done, not going into this. X, Y, and Z are partners in a firm. They were carrying their business successfully for the past several years. Spouses of X and Y fought in the ladies' club on their personal issue, and X's wife was hurt badly. X got angry on the incident and convinced Z to expel. Cannot be expelled because there is no partnership interest, lack of partnership interest, and when the expulsion is not in good faith, the expulsion is null and void. So state whether they can expel a partner from the firm. No. What are the criteria for the test of good faith? I'm not going into it, we all know it. X, Y, and Z are partners in a firm. They were carrying their business successfully for the past several years. Due to expansion of business, they plan to hire another partner, Mr. A. Now the firm has four partners, X, Y, Z, and A. The business was continuing at a normal pace. In one of the formal business meeting, it was observed that Mr. Y misbehaved with Mrs. A. Mr. Y was badly drunk and also spoke rudely with Mrs. A. Mrs. A felt very embarrassed and told her husband, Mr. A, about the entire incident. Mr. A got angry on the incident and started arguing and fighting with Mr. Y in the meeting place itself. Next day in the office, A convinced X and Z that they should expel Y. Well, definitely Mr. A had very much of interest in the expulsion, but definitely the expulsion was not in partnership interest, right? And he was also expelled without any notice. Wow, मतलब good faith का तो पूरा एकदम, you have literally shot the whole concept of good faith. Considering the provision, state whether the expulsion, whether they can expel. No, they cannot. What are the criteria of good faith? We have already done it so many times. Okay, this question just looks huge, but the question is actually super easy. Mr. A, Mr. B, and Mr. C were partners in a firm which is engaged in the business of trading of branded furniture. The name of the partners was clearly written along with the firm name in front of the head office of the firm as well as on the letterhead of the firm. On 1st October 2018, Mr. C passed away. His name was neither removed from the list of partners as stated in the front of the head office nor from the letterheads of the firm. As per the terms of partnership, the firm continues its operation. The accounts of the firm were settled and the amount due to the legal heirs were also determined. So he passed on 1st October, it was determined on 10th October, but the same was not paid. On 16th October, A supplier supplied furniture worth 20 lakh to Messrs. ABC and Company. Messrs. ABC and Company could not repay the amount due to heavy losses. Mr. X wants to recover the amount not only from the firm but also from the legal heirs. Are they liable? Not liable. Who is not liable? The legal heirs are not liable. Obviously, ABC and Company is liable because they made a contract. But the legal heirs of Mr. C is not liable because he is dead. And after his death, the order was placed, the goods were received. He is not liable. Mr. M, Mr. N and Mr. P were partners in a firm which was dealing in refrigerators. On 1st October, Mr. P retired from the partnership but failed to give public notice of his retirement. If a partner fails to give public notice of his retirement, there is some problem with this because of which the other side is actually not visible. Um, he did not give public notice, so he will be deemed to be a partner of the firm. Right? If a partner retires without giving any public notice, he is deemed to be a partner of the firm. But obviously, sleeping partner does not have to give any notice. After his retirement, Mr. M, N, and P visited a trade fair and inquired about some refrigerators with latest techniques. Mr. X, who was exhibiting the refrigerator with the new technique, was impressed with the interactions of P and requested him for the visiting card of the firm. The visiting card also included the name of P. ये तो बहुत ही ज़्यादा मतलब too much. As a partner, even though he had already retired, Mr. X supplied some refrigerators and could not recover the money. Now he wants to recover the dues not only from the firm but from P. Is he liable? Yes. If a partner retires from the firm without giving any public notice, he will be liable for the subsequent acts of the firm as a partner by estoppel or holding out. State the legal consequences of the following. We have already covered this. Insolvency: when a partner becomes insolvent, he ceases to be a partner of the firm from the day he was adjudicated to be a partner, to be an insolvent by the court. When he is insolvent, the firm is dissolved. Even if the firm, but if they want, they can continue. Even if the firm is not dissolved, the partner is no longer a partner of the firm. He generally has no rights or liabilities because we will use his share in the partnership to pay the partnership debts. Messrs. ABC Associates is a partnership firm since 1990. Mr. A and Mr. B and Mr. C were partners in the firm since the beginning. Mr. A, being a very senior partner, transfers his share to his son, Mr. Pratik, a chartered accountant. Mr. B and C were not interested that Pratik join them as a partner. After some time, Pratik felt that the books of accounts were displaying only a small amount of profit despite a huge turnover. He wanted to inspect the books of accounts, arguing that it is his entitlement as a transferee. However, the other partners believe that he cannot challenge the books of accounts. Can he be introduced as a partner if his father wants to get retirement? Well, the talk can he, first of all, let's talk about whether he can be taken as a partner, right? So a partner can actually transfer his shares. So can he be taken as a partner in his father's place? Here they have talked about introduced as a partner, but what they are talking about is he wants to transfer his shares. So we are talking about in the way of transfer. So can the shares of Mr. A, the partner, be transferred to his son? Yes. But for this transfer, we need what? We need the consent of all, or we need express agreement. Can he check the books of accounts? As far as the transferee is concerned, right, he is not allowed to check the books of accounts. So he has no right to check the books of accounts, so he cannot claim that right at all. Messrs. XYZ and Company is a partnership firm. The firm is an unregistered firm. The firm had purchased some iron rods from another partnership firm, Messrs. LMN and Company. which is also unregistered. So XYZ and company has purchased goods from LMN and company, right? And both of them are unregistered. If you remember, if the firm is an unregistered firm, it faces many disqualifications. One is it cannot sue a third party. So, Messrs. XYZ and company could not pay the money. So, Messrs. LMN and company decided to file a case against XYZ and company for the recovery of price. State under the provisions of the Partnership Act both are unregistered. So, can LMN and company file a case against XYZ? No. The partnership firm can file a case only when the firm is registered. Here, LMN is not registered. XYZ need not be registered. The firm filing the case has to be registered. The firm filing the case has to be registered. Since LMN and company is not registered, they cannot file a case against XYZ. What would be your answer if XYZ is registered, but this is unregistered? Still the same. Because the whole point is that LMN has to be registered. The whole point is that LMN has to be registered. The firm suing the third party should be registered. It's not necessary that the third party should be registered. What would be your answer if both of them are registered? If both are registered, then the suit is valid. But if LMN is not registered, the suit is not valid. What is the difference between dissolution of firm and dissolution of partnership? Dissolution of firm means the whole firm comes to an end. Dissolution of partnership means the business continues. The firm does not come to an end. Dissolution of partnership, only the relation of the partners is changing. Whereas dissolution of firm involves the whole winding up of the firm. Dissolution of firm is definitely dissolution of partnership. But dissolution of partnership is not dissolution of firm. In case of dissolution, the books of accounts are of firm, the books of accounts are closed finally permanently, but it is only temporary closing of books. What are the consequences of non-registration of partnership firm? It cannot sue a third party, it cannot claim a set off of more than rupees 100, and the partners cannot sue each other except for the dissolution of the firm. What are the rights which won't be affected by non-registration? Third party can sue the firm. Third party can sue the firm. If a partner of an unregistered firm wants to sue the other partners to dissolve the firm, even an unregistered firm's partner can sue the other partners. Already done this. What is partnership deed? Where it's an agreement. Partnership is always formed by an agreement. When the terms of the agreement are converted into writing, it's known as partnership deed. What it has the name of the firm, name of the partners, the place of the business of the firm, the nature of the business, the date the partnership will start, the day the partners are joined, the duration, the capital contribution, profit sharing ratio, the rules for admission and retirement, the rates of interest on capital, drawings, loans, provisions for settlement of accounts in case the firm goes for dissolution, salaries, commissions payable to the partners, what will be the rules for the expulsion of the partners. But apart from this, partners can also add or delete any of the provisions. They can add anything they want, they cannot add anything they want. What is the procedure for the registration of the partnership firm? With all of this, it will be sent to the registrar of the firm in whose state the firm is registered. The registrar, on satisfied that everything is fulfilled, will issue a certificate of incorporation. The name of the firm should not contain words like crown, emperor, empress, prince, empire, imperial, all these, right? X and Y are partners in a firm. The firm was dissolved on 12th June, but no public notice was given. And if we remember it correctly, the partners remain liable till public notice is not given. Thereafter, X purchased some goods in the firm's name from Z. Z was ignorant of the fact of dissolution of the firm. X became insolvent and Z filed a suit against Y for the recovery of his amount. Is he liable? Yes, he will be liable, because unless public notice is not given, the partners remain liable. So, partners remain liable till public notice is not given. P and Company is registered as a partnership firm in 2018 with A, B and P as partners dealing in sale and purchase of motor vehicles. On 1st April, in April 2019, A dies. Now only B and P continue the firm with the same business and the same firm name. In the month of December, firm felt the need of expansion of business and sharing the burden of expenditure and investment. They thought of hiring a new partner with mutual consent. They took a new partner S. The firm had supplied large amount of materials to one of the clients, Mr. X, and for business purpose. In spite of regular reminders, X failed to pay the debts. In January 20, the firm filed a case against X in the name and on behalf of P and Company without fresh registration. If a partnership firm wants to sue a third party, two conditions have to be fulfilled. First, firm must be registered and partners suing should be named as partners. Here, they took S as a new partner. Right? They took S as a new partner, but there was no registration. That means S's name does, when we say partners should be named as partners of the firm, that means in the records of the registrar, the name of the partner should appear. Since fresh registration was not done, S is not recorded as a partner. So S's name is not there in the register. So is the suit valid? This condition is fulfilled, but this is not fulfilled. So is the suit valid? No. Without fresh registration, unless the fresh registration is done, the suit is not valid. So is the suit valid? No. Why? Because S is not named as a partner of the firm. A and Company is registered as a partnership firm in 2015 with A, B and C as partners. In 2006, A dies. In 17, B and C sue X in the name and on behalf of the firm without fresh registration. Now what the point says, firm must be registered. This is fulfilled. Partners suing should be named as partners of the firm. A, B and C were named as partner. A is dead, but there is no fresh registration. Now, who is filing the case here? The case is filed by B and C. So, when the case is filed by B and C should be registered as partners of the firm. Are B and C registered as partners of the firm? Yes. So, is the suit valid? Yes. So, is the suit valid? Yes. Decide whether the suit is maintainable. Whether your answer would be same if in 2017 they took D as a new partner. Now, when they take D as a new partner, and without fresh registration they file a case, D's name does not appear. But ma'am, B and C can file. No, so even if B and C are filing, the case is filed on behalf of the firm. And because D's name does not appear, he is not named as a partner of the firm. So in this case, the suit is not valid. So here the suit is maintainable, but here the suit is not maintainable. State the grounds on which a firm may be dissolved by the court. The court may order in case of permanent incapacity of a partner, perpetual losses, misconduct of a partner, then consistent breach of contract by a partner, business becoming illegal, partnership becoming an illegal association, or except when all are dead or all are insolvent, then deadlock in the management or any other just and equitable grounds. G, I and S were friends and they decided to form a partnership firm and trade in a particular type of chemicals. After 3 years of partnership, a law was passed which banned the trading of such chemicals. As per the provisions, can G, I and S continue the partnership or will the firm be dissolved? It will be dissolved. Why? Because now the business has become illegal. And when the business of partnership becomes illegal, the firm has to be dissolved. What does Dissolution of partnership. When does, dissolution of partnership take place under the provisions of the Act? So it can be without the order of the court or with the order of the court. Without the order of the court, it can be by agreement. That is, all the partners mutually decide to dissolve the firm on the happening of certain contingencies. A partner is dead, a partner is insolvent, the firm was formed for a period, the period is over, the firm was formed for a purpose, the purpose is over, except one, all are dead or all are insolvent. In all of these cases, the firm can be dissolved. If it is a partnership at will, any partner can give a written notice and dissolve the firm. With the order of the court, I just discussed permanent incapacity of a partner, all those cases, not going into that again. When does dissolution of partnership firm take place under the provisions of the Indian Partnership Act? We already discussed all of these cases. MN Partnership firm has two different lines of manufacturing business. One line is manufacturing Ajinomoto, a popular seasoning and trade enhancer. Another line is manufacture of paper plates and cups. One fine day, a law is passed by the government banning Ajinomoto. That means now this business has become illegal. So the question is, should we dissolve the firm or only that business? Use in food and to stop its manufacturing, making it an unlawful business because it is injurious to health. Should the firm be compulsorily dissolved? No. How it will affect the other line of business? It will remain unaffected. When I have one business that becomes illegal, the firm has to be dissolved. When I have multiple business, one becomes illegal, I can just dissolve that particular business and carry on with the rest of the business. Miss Lucy, while drafting partnership deed, taken care of few important points. What are these points? She wants to know the list of information. As such, there is no such points because there is no format at all. Regarding the partnership deed, you can form it in any way you want it. It should be called as the partnership deed. It should be stamped, that is, it should be prepared on a stamp paper. That is it. What are the contents? We have already discussed. Subject to an agreement by the partners, state the rules that this should be observed by the partners in settling the accounts. So while settling the accounts, we first settle the outside liabilities. After the outside liabilities, we settle the partners' advance, then partners' capital, and then if there is any surplus, is divided amongst the partners in their PSR. In case the firm's assets is not sufficient to pay up to the partners' capital, it's a deficit. And in case of deficit, the partners have to contribute personally to the assets of the firm in their profit sharing ratio. If a partner has both partnership debts as well as personal debts, his I'm so sorry. If he has both personal as well as partnership debts, his personal property will be first used to pay his personal debts and then his partnership debts. With this, we are done with partnership. I hope this helps you. It kind of actually is a revision of the entire act. So I hope it helps you. All the best. Happy learning and stay motivated.